So tonight's topic is housing discrimination. And before we start, I just want to give this kind of qualifier that this is going to be a broad overview of housing discrimination, because the whole topic could never be completely dealt with in one sitting. Pretty much each slide that we're going to look at today could be unfolded into a training or a workshop all by itself. But we're going to look overall at what are all the different kinds of housing discrimination that are prohibited by city, state, or federal laws, and uh, what kind of activities are covered, who is covered, and what you can do if you think illegal housing discrimination is going on. So first, I just want to say the organization that I work at, TakeRoot Justice, is a free legal services provider. We especially work with groups of tenants who are organizing, such as through Cooper Square and a lot of the folks on this call. So tonight, first, we're going to look at what are all the laws that apply in New York City about housing discrimination. And then we're going to look at exactly what kind of discrimination is illegal. So against whom, by whom, and then what kinds of activities are covered. We're going to go deeper into discrimination laws around disability because they work very differently from most of the other anti-discrimination laws. And so there's just a lot to cover there. And then we'll talk about what you can do, where you can go if you believe that illegal discrimination is happening, some government resources and some organizations. And then we'll have a chance for Q&A at the end. And as always, Q&A also includes sharing wisdom and sharing experiences because besides me, the lawyer, there's a lot of experience and wisdom on this call. And again, as Jonathan said, when we get to that part, we'll turn off the recording so that people can more freely share information about what they've experienced. Okay, so let's jump right in and talk about where discrimination law comes from. This is a simplified list, but for the most part, when we're talking about housing discrimination, we are talking about the New York City human rights law. We're talking about the New York State human rights law, which is similar to the New York City human rights law, but not identical. And then federal law, which tends to be very different from New York City and state. And for the most part, that's the Fair Housing Act, which is also known as the Civil Rights Act of 1968. It was first passed in the 60s, and it has been amended many times since then. And the Americans with Disabilities Act that was passed in the early 1990s and covers a lot more than housing, but is uniquely the source of laws, requirements for reasonable accommodations in housing and in housing programs. Again, if we were going to do a full list of every law that involves anti-discrimination, there are many. But for the most part, everything that we're going to talk about, and I'd say 99% of the law of the rules against housing discrimination in New York City come under one of these four laws. And there are a lot of other laws that might apply only to a particular type of housing, like Section 8 or Mitchell-Lama. But for the most part, those laws mimic these laws. They usually contain the same definitions and the same coverage. Okay, so again, in the context of the whole United States, New York has relatively strong anti-discrimination laws. New York City has very strong anti-discrimination laws compared to most of the country, maybe not very strong compared to what we'd like to see. And then there's a really big gap between that and federal law, which tends to be much more limited and much more conservative because of how difficult it is to make a change at that scale. So let's start with what is it illegal to discriminate on the basis of? And we're going to be sharing these slides. This isn't going to be the first slide with a lot of words. Um, so you don't have to copy all of this down. But these are the bases that it's illegal to make housing decisions or provide housing or services based on these classifications, right? So in New York City, where we're covered by the city human rights law, the state human rights law, and the federal laws, we have the longest list. And so that includes age, citizenship or immigration status, criminal record, which is a little complicated, and we're going to take a closer look at that towards the end. Disability, which is its own kind of anti-discrimination law that we'll dive into. Status as a survivor of domestic violence. Family type, meaning including whether someone is married or not, whether there are children in the household. Gender expression, gender identity. Height and weight. Military status, meaning whether somebody's in active service or they're a veteran. National origin, pregnancy, race or color, religion or creed, sexual orientation, or source of income. That's a lot. And if you did not memorize it all or wrap your head around all of it, that is okay. The takeaways here, again, are if you look at this, anything that is in red is unique to New York City. So right now, that is actually only height and weight. What tends to happen is New York City often is the first one to pass or to expand discrimination laws. New York State often follows, and New York State has actually adopted most of what New York City has done over the last decade, so they're pretty close. Although in the details, the city and state may have some small but relevant differences in how they define things or exactly what somebody has to do or not do. And we're not going to be able to dive into those differences tonight because they are at a really fine-grained level of detail. Um, but again, for the most part, New York City and New York State are pretty close to each other. New York State is literally the same list except for height and weight. And then federal is anything in green is covered by all levels of the law. So federal law, which is the shortest and is probably the most familiar list because it's the list that gets repeated, that's listed at the bottom of most advertisements for housing, as well as things like, job postings. And that's disability, family status, gender, sex, national origin, race, color, religion, and creed. And one note, the federal law does not actually mention gender identity or expression. It only mentions sex. But in 2020, the US Supreme Court ruled that gender expression or gender identity, whether someone is transgender, whether they identify or express themselves as a gender at all, uh, the Supreme Court held that that comes under sex. So that's now a protected category in federal law as well. Here's the same table, but arranged a different way by which laws cover which categories. So the only thing that is only illegal in New York City is to discriminate in housing based on height and weight. New York State and city all make it illegal to discriminate on the basis of age, whether someone's a citizen, what their immigration status is, criminal record, whether they're a domestic violence survivor, their military status, whether they're pregnant, sexual orientation, or source of income. And then everything on the right is covered by all three. In addition to all of those categories that, describe people's identity or people's status, it's also illegal to discriminate on the basis of perception that a person belongs to any of those classes or statuses, even if it's incorrect. Association with a person in any of these classes. So it's illegal, to refuse to rent to somebody because of, say, the race of people that they associate with or have in their family or would have as a roommate. Um, Even if the discrimination is not based on any particular thing about the particular person who is applying for housing, right? It is still illegal to, for example, discriminate against me as a white man in housing because, uh, I, uh, am known to hang out with Black people or women, or to discriminate against an entire household because of the characteristics of one person. It's also illegal to discriminate as retaliation for somebody exercising their rights under any of these laws. So to discriminate against somebody because they reported or complained about suspected illegal discrimination, even if it turns out to be unfounded. Um, and as well as just generally advocating against illegal discrimination. So it would also be illegal to discriminate against somebody because they put a poster about housing discrimination on their door, or they talk a lot about housing discrimination, or they encourage a neighbor to make a complaint about housing discrimination. And those things are regardless of the characteristics of the person being discriminated against. In these cases, it would be discrimination just on the basis of these activities. Right? So who is governed by this? In other words, like who is being told by the law, you can't do this, right? Who could a discrimination claim be brought against? So for the most part, it's who you would expect. So it's people who control housing, right? That could be the owner. It could be a tenant who's subletting, or a tenant who has a ground lease. It could be the management. It could be the staff. So it's landlords in a broad sense, right? The person who's making these decisions about the housing, who controls the housing. It covers 1 to 2 family houses if not owner occupied, right? So if there's a 2 family house and the owner lives on the first floor and they're renting out the second floor, that is not covered by the discrimination laws. But if it's a 1 or 2 family house and all of the units are filled with renters, it is covered by the anti-discrimination laws. This also includes uh, parts of units, so renting out an individual room is covered here if it's not owner occupied. Uh, Multi-unit rental buildings, apartment buildings, SROs are covered. Condos are covered. Co-ops are covered. Mobile home parks, public housing, private housing that's regulated by the government or funded by the government, such as Mitchell-Lama or Section 8 housing or tax credit housing. Uh, Program housing, it's like housing that's part of some kind of program, like a homeless shelter or supportive housing for people with disabilities, or housing that is related to drug treatment. Those things are all covered, though we'll see in a few slides that there are some exceptions for them. And finally, dormitories. So college dorms, school dorms are covered by all of this. They're also covered. They're double covered because they're covered by laws that prohibit discrimination in schools. But the dorms themselves are covered as housing. They are recognized as forms of uh, rental housing under city, state, and federal laws. And then other entities that are covered are real estate brokers, right? The people who show you or help you connect with rental units or help you buy or sell. Mortgage lenders and mortgage brokers, so banks and all the mortgage agents. And then advertisers. So businesses or services that advertise housing sales or rentals as their business. All of those entities are covered by these laws, and there are things that all of them, uh, are not allowed to do. Tonight, we're not going to look very much at mortgage and buying housing, just because we know that most of the people here, if not all, are tenants, and that's who the majority of people in New York City are as well. So there are some exceptions to this. The city and state law actually allow there to be single gender buildings. So there are women's residences. I don't think that there are any existing men's residences in New York City, but I could be wrong. And if there are, they are exempt from discrimination on the basis of sex, right? So they can limit to men or women, but they are still prohibited from discriminating on the basis of gender expression or gender identity. So they can't, for example, say this building is only for women who dress in a traditionally feminine way. Um, Religiously affiliated housing obviously can discriminate on the basis of religion. Uh, and when it comes to the federal laws, the Supreme Court has created all kinds of exceptions, allowing religious organizations to get away with discriminating on a whole bunch of other bases. The takeaway here is just that if the housing is operated by a religious organization and it's engaging in housing discrimination on some other basis, um, then it would be illegal under city and state law. But federal law would not be that helpful there. The Supreme Court has made so many carve outs. And then some program housing can be limited to certain populations where it's an essential part of that program's purpose, right? So, for example, senior residences can discriminate on the basis of age and require that people be above a certain age to live there. There are uh, homeless shelters that are only for families with minor children, or only for single adults, or only for youth. There are, domestic violence shelters that are, of course, limited to survivors of domestic violence. And I'm sure you can think of other kinds of housing that is limited to a particular population because that's the program that's being provided. So in those cases, they can discriminate, but again, only insofar as it's necessary for the program's purpose. So if a shelter for single adults, a shelter for single adults can say, families with minor children cannot live here because it's not designed for it. But they can't then go on to say, and also, only people of a certain race can live here. So again, limited exceptions where the housing is part of a program where in order for them to carry out the core functions of the program, they have to make certain limitations for population. And then, so we talked about who is protected, we're talked about who is uh, being governed here. And this is the kinds of activities that are covered. This is not a complete list because there's a broad catch-all here that just says that it's illegal to make decisions about housing, about access to housing, or about how people, what kind of housing people have based on those categories. But these are some of the major kinds of things that are covered, right? So before somebody actually moves in, right, when they're applying for housing, there cannot be discrimination in how the housing is advertised. It cannot say, you know, this is limited to a certain group. And in fact, it often can't even say things like, this is perfect for a single adult who wants to have fun on the Lower East Side. They can't even use language that would just tend to discourage people or give the impression that the housing is not suitable for them. Uh, Showing or guiding, so a real estate agency's, a broker's activities, right, in deciding who they will provide services to, but also what apartments they'll show people, where they steer them, right? Do they bring people to look at apartments only in a certain neighborhood because of that person's race or because of perceptions about that person's identity? When it comes to applying, the process for application has to be the same for everybody, and the forms to be filled out have to be the same for everybody. So it could be illegal housing discrimination. If a landlord requires some people to go through a background check because say of that person's race or color, and other people to not have to go through a background check, or to provide different numbers of references. The decision of whether to rent the apartment to somebody definitely cannot be based on any of these categories. The rent to be charged or any other terms and conditions of a tenancy also can't be based on somebody being in any of these categories. Once somebody is living in the housing, other things that cannot be based on these categories, whether your lease is renewed or extended, whether you're charged fees or not, or how much the fees are, what access you have to services or amenities, the kind of repairs you get, uh, whether the landlord targets you for eviction. None of that can be based on any of those characteristics, those classifications that we went over. And then when it comes to buying and selling property and mortgages, it covers things like the advertising, the real estate brokers, the who banks will loan to, the terms of their loans, um, how the seller treats different people who make offers on the property, price, terms, conditions of sale. It pretty much parallels the rental process. Again, none of those prohibited categories can be the basis for treating anybody better or worse in any of these activities. Now we're going to spend some time zooming in on discrimination on the basis of disability. And the reason for that is that disability anti-discrimination laws are structurally very different from other kinds of discrimination laws. So all of those laws say you can't treat somebody worse because they have that characteristic. And that's true of disability as well. You can't treat somebody worse because they have a disability. But in addition, Um, Under the Americans with Disabilities Act and the disability provisions in the city and state laws, uh, a landlord or a housing provider has to do more than just not be biased against people who have disabilities. There's actually a duty, an affirmative duty, to make accommodations, meaning changes that are necessary so that a person with a disability can use and access and enjoy the housing equally to how a person without a disability would be able to access it, which all goes to say that landlords are often required to actually change things to make housing accessible to people with disabilities. And so before we go into what that looks like, I just wanted to go over how the law defines a disability. Um, this definition, there are differences in nuance and detail between the three different levels of law: city, state, and federal. But for our purposes, they are all saying the same basic thing, right? A disability is a physical, mental, or sensory impairment. So it doesn't just have to be bodily, it can also be mental or cognitive, that substantially limits a major life activity. So the one way to say that is it has a real practical impact on how somebody is able to move through the world. Major life activities is there's no definitive list, but these are the ones that are often given as examples in the laws or by the agencies. These are things that if a condition impacts your ability to do this, it could be a disability. So those include things like taking care of oneself, bathing, um, getting around, mobility, basic bodily functions like eating, sleeping, breathing, using the bathroom, communicating with others, to be able to understand others' communications, interacting with others and forming relationships, learning, thinking, or concentrating. This is not an exhaustive list, but this is hopefully it will give you a sense of like what kinds of things or what scale of things we're talking about as major life activities. And I'm sure people could add more to that list. But the effect of this in law is that part of the determination of whether a condition is a disability is to look at how it impacts somebody's life, right? Um, have does it cause a person to go through life and interact with their surroundings in a different way than they would if they didn't have a disability? It can also be a history of having a condition, even if one doesn't have a condition right now. And that's based on the idea that some conditions are chronic, they may come and go. And so a person may not at this moment need a modification to an apartment, but they may know that, in order for them to live there long term, there's going to have to be a modification. So when somebody has a disability, a housing provider is required to provide a reasonable accommodation. And reasonable accommodation is a phrase a lot of people have probably heard. And what it is a change in the housing provider's rules or policies or services or physically to the housing itself that is necessary for a person with a disability to have the same opportunity, an equal opportunity to access and use and enjoy that housing as somebody without a disability. And there's no limit on what on what could be a reasonable accommodation. But here are some common examples of reasonable accommodations. Allowing somebody a service animal or an emotional support animal when the lease otherwise says no pets. Making a modification like putting in a ramp or widening a doorway to accommodate a wheelchair user. Helping somebody fill out forms if they're visually impaired. Whereas the landlord doesn't provide that kind of service to other tenants. Um, a landlord has a rule that says everybody's got to pay their rent in person at the office. A reasonable accommodation could be making an exception for somebody who's homebound or mobility impaired. Somebody whose disability means that, they have limited ability to get out of the home and go to the bank. It could be a reasonable accommodation for a landlord to say, you can pay anytime in the first 2 weeks of the month instead of the first 5 days, because you can't always get to the bank because of your disability. Relocating somebody to a first floor apartment because they use a walker and there's no elevator. But also, accommodations of what are sometimes called invisible disabilities, which could be mental health disabilities or cognitive or developmental disabilities. So, just like a landlord may have a duty to relocate somebody to the first floor if they can't climb stairs, they also might have an obligation to relocate a tenant, let's say, who has post-traumatic stress disorder that's triggered by loud noises, to an available apartment at the back of the building where things are quieter. Um, it also can mean um, communicating or interacting differently with a tenant who has, say, a mental illness and communicates differently, more slowly, or has certain needs to be approached in a certain way. There is a limit, though. I mean, the word reasonable in reasonable accommodation is a limit, right? It doesn't mean that every accommodation is necessary, but only accommodations that are reasonable. And an accommodation is not required if it would impose an undue hardship on the housing provider. And so examples of that would be something that is very expensive as opposed to, it's a cost, but it's not a very difficult cost for a landlord to pay. Or it would damage or make a permanent change in the use of the building. Or it would be illegal, or it would significantly interfere with other people's rights. Or if this is a housing connected to a program, it would defeat the essential nature of the program. And so here are some examples of that, right? So it would be a reasonable accommodation to make the building's front door automatic, because that's fairly easy to do and it's not very expensive and it won't make the building fall down. Uh, but on the other hand, saying, well, this is a 6-story walk-up building, uh, you know, and somebody moves in and says, I want there to be an elevator, it would not be a reasonable accommodation to say we're going to gut renovate the building to accommodate it, to contain an elevator shaft, right? So major alterations like that would be undue hardships. A reasonable accommodation would be, training the staff to be, thoughtful and appropriate in the way that they interact with someone who's got a mental illness, right? Being more patient or just being aware that a person needs to be talked to in a certain way. But it would be an undue hardship to say that a tenant, because of mental illness, could threaten or abuse or be violent towards their neighbors. It could be a reasonable accommodation in senior housing to have somebody, let their adult child live with them who's not a senior. because they're their caregiver and the senior can't live in the apartment without them. That would be a very common reasonable accommodation, where you're making an exception to the rule that says everybody in the building has to be 60 or over. An undue hardship would be to essentially, abandon the policy goal of the housing by just having a non-senior get to live there permanently by themselves, right? That would be a fundamental change to what the housing is there for, right? A reasonable accommodation could be relocating someone to an available first floor apartment because they can't climb stairs, right? An undue hardship would be relocating someone to a 5,000 square foot commercial loft space because it's available and would better meet their needs, right? It would be legal for a landlord to say, no, I'm not going to do that because of the cost of that is far beyond, a reasonable cost, like, making modifications to a shower. Where the exact line is between a reasonable accommodation and an undue hardship is not always easy to tell. There can be big fights over it. There can be fights where each side brings in their experts to try to make their point about just, how feasible would it be to put a ramp in front of this building, or how much would this cost? There are also, you know, within these distinctions, there's also a lot of value judgments about what we expect of each other, what we expect of neighbors. What should a neighbor tolerate? If they live next door to someone with a disability, and what should they not? And so these are often very contested and hotly contested decisions here. That said, it's very common. I mean, for the most part, landlords are far more likely to say that something is an undue hardship when it isn't than the other way around. I have seen many cases where landlords try to evict somebody because, oh, you have a disheveled appearance and you talk to yourself, and that's disturbing, and we don't like looking at it, right? That would be a discrimination on the basis of disability, since it's perfectly reasonable to expect building staff and neighbors to live with somebody who they just don't like the way they look. Um, on the other hand, somebody whose symptoms of their mental illness cause them, for example, to pound on people's doors in the middle of the night, or threaten people or scream at them, um, you know, will cross a line. And generally, you'd expect a court or an agency will say, well, people don't have to live with that. Um, but exactly where these lines fall can be very hard to predict. It can be very nuanced. It can be based on very fine details. And it can change over time as our expectations, as our social norms and expectations change. Okay, uh, we we've barely scraped the surface of disability discrimination, and maybe that should be, a workshop topic going, in the future. But I think we've gone over the basics of it that we can fit in tonight. So I want to switch to another piece of New York City discrimination law that has kind of complicated workings, right? That is more than just saying you can't mistreat people based on this characteristic. And that's the Fair Chance Housing Law, which is a law that was passed just a few years ago that makes it partly illegal for landlords to refuse to rent to people because of criminal history, criminal records. That is not part of the state law. It is not part of federal law. Uh, this is another instance in which New York City is the first, and it's, fairly likely that the state will follow. And, uh, I'm just not going to comment on what the federal government might or might not do at this time. So this applies to when a landlord can refuse housing based on somebody having a criminal record, right? So it is legal for a landlord to require a criminal background check. But that check can only be made after the landlord has reviewed everything else about the candidate and made a conditional offer. In other words, uh, the landlord has to say, I'm going to rent, based on everything you've shown me, your finances, your references, um, I will rent to you uh, if you pass a criminal background check. So the purpose of structuring things that way is because if the law just said you can't discriminate on the basis of a criminal record, then of course a landlord can look and see that somebody has a criminal record, decide not to rent to them on that basis, but then just say, well, I'm not renting to you because I don't like your finances. And so this makes it harder for that to happen, right? Because a landlord has to basically go on the record saying everything else about you looks good, right? And then when they do a criminal background check, they still can uh, refuse to rent to somebody based on what is in the criminal record, if that includes crimes that require someone to register as a sex offender, um, felony convictions, where the actual date of release from prison was within the last 5 years, misdemeanors where the actual date was in the last 3 years, or reasons unrelated to convictions that have to be written. So, in other words, you may notice this doesn't, go very far in prohibiting landlords from discriminating on the basis of criminal records. Its main impact is it makes it much more difficult for landlords to discriminate on the basis of criminal records from years back, right? So, where somebody completed their sentence more than 5 years ago. Um, Okay, and they can't ask about that's only for convictions. It is illegal to refuse to rent to somebody because of arrests that didn't result in convictions, cases that are still pending, so there's been no conviction, ACD, which is a certain kind of um, plea that basically just lets charges go away without any conviction if somebody is able to not be arrested for violating any other laws for a certain time. Also convictions from when someone was a juvenile or anything that's been sealed or expunged. So again, only felonies where the person was released within the last 5 years, misdemeanors in the last 3 years, um, and sex offenses. So, and this applies only to multiple dwellings, which means 3 units or more, and it does not apply to any public housing or housing that is federally subsidized, because there the federal laws win out, and they include very, very strong prohibitions against renting public housing or federally subsidized housing to people with criminal records. And the city and state just don't have the authority to override those. So if you believe that illegal housing discrimination is happening to you or to somebody else, uh, some places that you can go, right? So there are agencies at the city, state, and federal level that you can go to, and you can also go to court. So in New York City, for any violation of the city human rights law, you can go to the New York City Commission on Human Rights and make a complaint there. This is only for violations of the New York City human rights law, although since that's the broadest, any violation of housing discrimination laws is going to be a violation of the city law. Um, it changes with the administration, but historically, the city commission has been better resourced, more responsive, more proactive than the state division has been. And people have usually found it to be easier to interact with. Um, the state division of human rights obviously would apply to anything outside of New York City, and also applies to other kinds of discrimination beyond housing discrimination. There are some kinds of discrimination that you would have to go to the state division for, but that doesn't come into our workshop tonight. And then there, at the federal level, if there is a violation of federal law, you can go to HUD, Housing and Urban Development. Um, First of all, that's much more limited because the federal laws are more limited. And as you probably know, their interest in or the resources they have for actually doing anything have been drastically cut back under this administration. Um, you can also go to the New York State Attorney General, and on some of the slides after this, there are links for all of this. But in general, going straight to the Commission on Human Rights is usually more useful than the Attorney General, just because the Attorney General has a very wide jurisdiction over all kinds of discrimination and less resources specifically for housing discrimination. And of course, you can always go to court. Um, you can go into New York State court for any uh, illegal discrimination, whether it's the city law or the state law or federal law. Um, you can go to federal court. Federal court will only have jurisdiction over the federal laws. And sometimes you can bring along with that some state or city laws if they're really intertwined with each other. And then for government regulated housing like Mitchell-Lama or HDFCs or public housing, there's going to be a city or state agency whose job is to oversee that housing, like HPD or DHCR or the Housing Authority. And they usually have some kind of complaint process internally there. So, none of these are the right or the wrong way to go. You have the right to use any of them. You have some right to try to use all of them, though in the end, if you're pursuing a claim, you usually have to pick one or the other. But there are also different things that they can do. So, for example, the Commission on Human Rights and the Division of Human Rights can actually investigate on their own. So if you make a complaint, they can reach out to a landlord or a housing provider and ask them questions or look at their records or demand that they produce records. Whereas if you go to court, a judge can't do that. It's all up to you and your lawyer to present whatever information you can get. The commission and the division are much more approachable in the sense that they're set up for people to be able to go to them and file complaints and interact without having a lawyer, right? So the processes are simplified. Most things are pretty common sense. And in fact, when it comes to reasonable accommodations, the city commission actually has a program where they will reach out to your landlord to make a reasonable accommodation request. for you if you're nervous about doing it and possible retaliation, or you're not sure how to do it. They'll take that first step. So it's even possible to go to the commission where there hasn't actually been discrimination yet. You just want to ask the landlord to provide you with your right to an accommodation. And obviously they can make requests that are targeted, that have the right legal language. And of course, it puts the landlord on notice that the government is watching them. So they're much more likely to be on their best behavior, than if you do it by, emailing the super. Um, Again, as always, we will share the slides so you do not have to write down all of these links, but these are, the links to the most useful parts of those websites, where they have fact sheets or where they describe know your rights, or where they have forms to make complaints. I do want to say something about the HUD website. This presidential administration has gone through all kinds of federal websites and put in really gratuitous and offensive language about minority groups. That is shocking and offensive. So, for example, uh, to go even to the link there in the page on the Fair Housing Act, um, include some language about rules that they've revoked in the Trump administration, uh, that includes just like denigration of the groups that those rules were meant to protect. I'm including them here because there still are at the core of these websites, important information that's been there for years, and including information about how to make federal complaints. So, there are things there that we may need to know. I just, to beware that one of the Trump administration's favorite things has been going through the websites and making them look like a racist Donald Trump tweet. These are non-government resources. This is an incomplete list because there's so many different legal offices or organizations that can be useful, but these are some of the most on point in New York City for housing discrimination. So the Fair Housing Justice Center is an organization, a nonprofit that is dedicated to investigating housing discrimination and challenging it. So if they get reports that a particular landlord or housing provider or real estate broker is discriminating, they will actually send actors, what's called paired testing, right, to applicants with basically equivalent credentials, but one of whom, it belongs to a minority group and the other one doesn't. And to do this a number of times in order to get evidence, to investigate and get evidence of illegal discrimination. So if you think that you've encountered, uh, a broker or a landlord who might be doing this discrimination in a systematic way, uh, reporting it to the Fair Housing Justice Center. If they're hearing of that from a number of places, they may target them for investigation. And where their investigations turn up actual evidence of discrimination, they'll often then bring a lawsuit. And they partner with some big law firms that have deep pockets to do that. They also more generally just have a lot of useful fact sheets, information, and they sometimes give workshops or have videos for people to learn about how to spot housing discrimination. The Legal Action Center is a free legal services office that is specifically targeted for people who've been denied housing because of because of a disability, because of a health condition, or because of criminal record. New York Lawyers for the Public Interest has a disability justice project, which again focuses in on systematic discrimination. So they're most interested in cases where it looks like a landlord is doing this to a lot of people or to the public in general. Um, Mobilization for Justice, MFJ, used to be MFY, is another free legal services office. They have projects specifically for uh, people with disabilities, including people with mental health disabilities. And they also have housing programs for seniors. So uh, this is a great place to go if somebody is not getting reasonable accommodation, or they're being discriminated against because they have a mental health disability, or because of age. And they also have a number of fact sheets up that are there. Again, folks know of other resources, please do share. There are literally hundreds of organizations in New York City that in some way support people who have disabilities, or who are trying to find housing and facing housing discrimination. These are, I think, the ones that it's easiest to access and to have the most capacity to respond to people.